Welcome to the deep dive. We are absolutely thrilled to have you with us today.
Yeah, really glad you're joining us.
Right. So whether you are prepping for an intense law exam, catching up on legal history, or, you are just insanely curious about how the rules of our society actually work, you are in the right place.
Absolutely.
Today's legal module takes us into the complex, highly visceral, and honestly often surprising world of strict liability for animal attacks.
It is a wild area of the law.
It really is. And to get to the absolute bottom of this, we are traveling back over a century to examine our specific source material. It's a fascinating 1920 Missouri Court of Appeals case called Carrow v. Haney.
Yeah, Carrow v. Haney. It is a truly remarkable case to unpack.
Mhm.
The fact pattern is incredibly dramatic, but more importantly, the legal logic the court uses remains highly relevant to how we view property rights and personal liability today.
Exactly. So I want to clearly frame our mission for you, the listener, right out of the gate. By the end of this deep dive, your goal is to completely master the legal doctrines of scienter and vicious propensities.
That's the core of it.
Right. We're going to figure out exactly what happens when a seemingly sweet household pet crosses the line in the eyes of the law, and how a property owner's knowledge changes everything.
And to achieve that mission, we have a very specific analytical path laid out for you.
Okay, what's the roadmap?
First, we are going to examine the foundational first bite doctrine, which sets the baseline for how the common law historically views domestic animals.
Okay.
Then, we will break down the specific testable elements of strict liability for dangerous animals using a rigorous framework.
Right, the real nuts and bolts.
Exactly. And finally, we will explore how a victim's status specifically, whether they are on a property with a general lawful presence versus explicit spoken consent, fundamentally impacts the dog owner's liability.
Okay, let's unpack this doctrinal foundation first. This is something you hear tossed around in pop culture all the time.
Oh, constantly.
How does the law actually handle a dog's first bite? Is it true that a dog always gets one free pass before the owner is held responsible?
That is a very common and frankly potentially dangerous misconception.
Really?
Yes, to answer it, we have to look at the general rule, which the court in our source material highlights by citing a precedent doctrine from an older case called Lyman v. Dale.
Lyman v. Dale.
Right. The general rule states that a dog is allowed its first bite, or as the rather colorful old legal phrasing goes, every dog is entitled to at least one worry.
One worry. Love that phrasing.
It's very historic.
Yeah.
But here's the catch. The dog is entitled to that one worry, provided that the dog conceals its intention.
Conceals its intention. That phrasing makes the dog sound like some sort of calculating supervillain.
It does sound a bit premeditated. But in a practical legal context, it simply means the dog has never exhibited threatening behavior before. It has acted like a perfectly normal, predictable, safe pet up until the absolute moment of the attack.
Got it. So it's flying under the radar.
Exactly. However, the rule has a massive, vital exception.
Okay.
If the dog manifests vicious propensities or an inclination to bite, and the owner has knowledge of this aggressive behavior, the owner is not permitted to just sit back and let the dog carry out its designs before being held responsible.
So the free pass is gone.
The moment the owner has knowledge of that dangerous inclination, they become strictly liable, even if the dog has never actually bitten anyone before. The so-called free pass completely evaporates.
That is fascinating. So the law doesn't literally count the physical bites?
Not at all.
It evaluates the behavior and the owner's awareness. Let's analyze Carrow v. Haney. First, what are the legally dispositive facts?
To understand this, we have to transport ourselves to a Monday at high noon in 1920s St. Louis.
Okay, setting the scene.
Picture a close-knit, slightly bustling neighborhood. We have the plaintiff, a 7-year-old girl who went to a residence at 2103 Bremen Avenue.
And she was there for a specific reason, right?
Yes, she was there on a specific errand. She was collecting money for a church entertainment ticket from one of the defendants, a Mrs. Haney.
Just a normal neighborhood thing.
Exactly. The young girl approached the property and entered the premises through an unlatched lattice gate.
Completely unlatched.
Right. Suddenly, with almost no warning, a brown brindle bulldog ran out from the back porch.
Oh, wow.
It charged the 7-year-old and severely bit her on the legs, specifically tearing into her knees.
A 7-year-old just trying to collect church funds getting ambushed like that is a horrific image. And there was a warning sign on the property, correct?
Yes, there was a faded "Beware of the Dog" sign on the gate that had been posted for about 18 years.
18 years.
Yeah. But crucially, the 7-year-old girl could not read it.
Of course not. She's 7.
Exactly. Now, the aftermath of this brutal attack is where the facts get heavily disputed, creating the core tension of the case.
What happened?
The little girl's parents testified that the Haneys outright admitted the dog was vicious. The father testified that when he confronted Mr. Haney told him, "Yes, I know he is, but I'm keeping any damn dog I want on my premises."
Oh, that is quite the neighborly response.
It's incredibly aggressive.
And what was the defendant's side of the story?
The Haneys tried to paint a completely different picture. They claimed the bulldog was usually kept in a separate enclosure, had a sweet disposition, and had never bitten a single person before this incident.
A sweet disposition.
That's what they claimed. As for that 18-year-old beware of the dog sign, they claimed it was never meant as a genuine warning about a dangerous animal.
Then why have it?
They argued it was merely a bluff to keep out peddlers and tramps.
Right, because nothing says sweet disposition quite like an unprovoked bulldog ambush on a second grader. The contrast between those two stories is wild. And what was the core legal issue?
The core legal issue the appellate court had to decide was this. Did the trial court err in instructing the jury that the plaintiff could only recover damages if she proved she was on the defendant's premises with their express consent or permission?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the black-letter rule for strict liability regarding a dog bite.
Okay.
The rule has 4 distinct elements. First, the animal possesses a vicious propensity. Second, scienter, meaning the owner has knowledge of this propensity. Third, the plaintiff is injured without essential fault. Fourth, the plaintiff is on the premises for a lawful purpose.
Okay, that structure makes a lot of sense. You can't just have one element without the others.
Right, they all have to lock into place to establish liability.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, vicious propensity?
Let's look at the sub-issue here. Did this brown brindle bulldog actually possess vicious inclinations? The sub-rule we apply is that propensity is legally shown if the dog fails to conceal its intention to bite, or naturally manifests an inclination to do so.
So no more supervillain concealment.
Exactly. In applying the specific facts to this rule, the appellate court looked critically at the competing evidence. Despite the defense's rather hollow claims that the dog was just a pet with a sweet disposition, the court noted the sudden, unprovoked, and severe nature of the attack on the little girl.
It's hard to argue sweet disposition after that.
Very hard. Furthermore, the father's testimony that he had received a prior warning from Mr. Haney about the dog being vicious provided substantial evidence of a dangerous nature.
Makes sense.
The logical conclusion here is that the sweet disposition defense fails, and there was ample evidence for a jury to find that the first element, vicious propensity, is met.
So the evidence of the attack itself, plus the neighbor's prior interactions, completely outweigh the owner's claims that the dog was harmless. Understood. Now, what about the second element, scienter?
The sub-issue here is really the turning point of the case. Did the owners have knowledge of the dog's viciousness?
Right, did they know?
The sub-rule is that the owner must have actual notice or knowledge of the danger the animal poses to the public.
And applying the facts?
Applying the facts, the court focused heavily on those incredibly damaging alleged admissions.
Like the quote from the dad?
Yes. You have Mr. Haney's aggressive statement that he was keeping any damn dog I want, which directly implies he knew the dog was dangerous but obstinately chose to keep it anyway.
Definitely.
Additionally, the mother testified that Mrs. Haney admitted the dog's bad nature was the specific reason the beware sign was hanging on the gate.
Oh, completely contradicting their own bluff defense.
Directly contradicting it. These statements, if believed by the jury, unequivocally prove notice.
So the conclusion?
Therefore, the conclusion is that the second element, scienter, is met.
That quote from Mr. Haney is incredible. It perfectly captures that raw tension between absolute property rights, the idea that my yard is my castle, and the legal duty you owe to your community not to harbor a known menace. What about the third element, injury without essential fault?
The sub-issue we're looking at here is, was the 7-year-old plaintiff somehow at fault for her own injuries?
Did she provoke it?
Exactly. Did she tease the animal? Applying the facts to this element, the court recognized her status and reality as a very young child.
Right, she's 7.
She wasn't trespassing maliciously. She was merely following Mrs. Haney's prior instructions to return on Monday for the church ticket money.
Doing what she was told.
Crucially, because she was only 7, she was completely unable to read the "Beware of the Dog" sign.
So the sign is useless to her.
Completely useless. She simply walked through an unlocked, unlatched gate on a standard, innocent errand.
Okay.
The conclusion is that she acted exactly as a reasonable child would under the circumstances, meaning she was entirely without essential fault. The third element is met.
Makes total sense. You cannot reasonably blame a second grader for walking up to a house to collect a few coins for a church event. And what about the fourth element, lawful purpose?
This element is where the original trial court made its critical, fatal mistake.
Oh, really?
Yes. The sub-issue is, did the young girl need explicit, spoken consent or permission to be in that specific yard at that exact moment to recover damages?
What's the sub-rule?
The sub-rule here is vital for you to understand. After scienter is established, meaning once the owner knows they have a dangerous animal, liability applies whether the victim is explicitly invited onto the property or goes onto the property of their own volition.
As long as they have a lawful purpose.
Provided they have a general lawful purpose, yes. Applying this, the appellate court found that the trial court's jury instruction, which required the girl to prove consent or permission, was far too narrow and restrictive.
Because she was there for a lawful reason anyway.
Exactly. The young girl was on the property lawfully to collect a debt for a church ticket, an errand initiated by Mrs. Haney herself. She didn't need to prove she had explicit permission to enter the specific yard through that specific gate on that specific day.
So the conclusion.
The conclusion is that the fourth element, lawful purpose, is met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing this entire elemental analysis, the appellate court's ultimate holding was that the trial court's jury instruction was legally erroneous.
Because it was too restrictive.
Right. Because there was substantial evidence the dog was vicious and the owners knew it, they are strictly liable since the child was there for a lawful purpose.
Got it.
This remains true regardless of whether she had strict, explicit consent to open that specific lattice gate. Consequently, the appellate court reversed the decision and affirmed the order granting a new trial for the plaintiff.
That structural breakdown makes the court's reasoning incredibly clear.
It really highlights where the trial court went wrong.
They got too hung up on the idea of a formal invitation, completely missing the broader rule about harboring a known danger. But I want to really test this rule right now to make sure you, the listener, have this concept locked into your memory.
Let's do it.
Let's pivot to a visceral hypothetical scenario. Imagine a modern homeowner keeps a massive, drooling, rabid-looking beast of a dog in their front yard.
Okay, painting quite the picture.
Now, this dog has never actually bitten anyone, so it technically hasn't had its literal first bite.
Still got its free pass.
Right. However, every single time a delivery driver walks by the property, the dog aggressively snaps its jaws at the chain link fence, barking furiously, spraying saliva everywhere, clearly trying to tear into them.
Terrifying.
And the owner just sits on the porch and watches this display happen daily.
Okay.
One day, a delivery driver opens the unlatched gate to drop a package on the porch, which is undeniably a lawful purpose, and the dog lunges, taking a massive, gruesome chunk out of the driver's calf.
Wow. That is a highly visceral, terrifying scenario, but it is exactly the kind of fact pattern that perfectly illustrates the absolute boundaries of the law.
How does the analysis hold up?
If we apply the established rules to your hypothetical, the homeowner's attempt to use the first bite defense completely and utterly fails.
Because the dog hadn't concealed its intentions, right? It was practically advertising them.
Exactly. The historical rule protects a dog that conceals its intention, a dog that acts like a normal, peaceful pet. This hypothetical dog did the exact opposite.
Snapping and drooling.
Right. Snapping, drooling, and aggressive lunging at the fence are clear, undeniable manifestations of a vicious propensity. The dog was broadcasting its inclination to bite to the entire neighborhood.
And what about the owner's knowledge?
Second, we look at scienter. The owner was sitting on the porch watching this happen day in and day out. They had direct, undeniable knowledge, scienter, of this dangerous behavior.
They can't claim ignorance.
Not at all. Finally, the delivery driver opening the gate to drop off a package constitutes a lawful purpose.
Because they were just doing their job.
Exactly. Because the dog manifested its viciousness, the owner knew about it, and the victim was there lawfully without essential fault. Strict liability attaches immediately. The fact that it was technically bite number one is entirely irrelevant in the eyes of the law.
That really drives the point home. It is not literally about counting the physical bikes. It is entirely about observed behavior and the owner's knowledge.
Precisely. And for you, the listener, as you digest this legal module, it is absolutely crucial to be able to apply these concepts systematically.
You don't want to just memorize facts.
No, you want to master the application. So, to conclude our analytical portion, I am going to synthesize all the rules from this module into a step-by-step diagnostic checklist.
Perfect.
You can think of this as an actionable framework for issue spotting on a law exam, or simply a mental model to structure your legal reasoning when evaluating risk.
Excellent. I love a good diagnostic tool. Let's hear the framework.
Step 1. Identify the injury and the animal's history. You must ask, did the animal actually conceal its intentions, or did it manifest viciousness?
Conceal versus manifest.
Right. Remember, the old adage of one worry or the first free bite only applies to stealthy, unpredictable dogs that have never shown a hint of aggression. If the facts show a history of snapping, growling, or lunging at fences, the free pass is entirely gone.
Got it. Step 2.
Step 2. Pinpoint scienter. You need to aggressively hunt the fact pattern for owner knowledge. This is almost always the turning point of a strict liability case.
What should they look for?
Look for prior warnings given by the owner, admissions of the animal's bad nature, complaints from neighbors, or even the presence of a beware of dogs sign.
Like the Haney sign.
Exactly. And remember, as we saw in the Carrow case, a plaintiff will argue the sign is a genuine warning proving knowledge, while a defendant might try to claim it was merely a bluff. You must spot that inherent tension.
Spot the tension. Okay, step 3.
Step 3. Evaluate the plaintiff's status. Were they without essential fault? Did they actively provoke the animal by teasing it?
Or like the 7-year-old.
Right. Were they a young child incapable of reading a warning sign? Or were they a competent adult who blatantly ignored a locked gate and a verbal warning? The law treats those two victims very differently.
And the final step.
Step 4. The lawful purpose check. This is the trap where many students and practicing attorneys get tricked.
The consent trap.
Yes. Remember the holding in Carrow. Do not get baited into looking for explicit consent, a formal invitation, or permission to be on the exact square foot of the property where the bite occurred.
Because general lawful purpose is enough.
If scienter exists and the plaintiff is without essential fault, a simple, general lawful purpose, like delivering a package, reading a utility meter, or collecting a neighborhood debt, is all that is legally required to trigger strict liability.
That is an incredibly powerful checklist.
It's designed to cut through the noise of a complicated fact pattern.
It takes a complex, century-old appellate opinion and turns it into a razor-sharp diagnostic tool that you can apply to modern scenarios, from homeowners insurance claims to protections for gig economy delivery drivers.
The underlying logic hasn't changed.
No, it hasn't. As we rack up this deep dive, it is genuinely fascinating to step back and look at the broader policy at play here.
It really is.
The law so elegantly balances two competing ideas. On one hand, a person's absolute right to keep a pet, or as Mr. Haney so bluntly put it, any damn dog they want, and on the other hand, the absolute non-negotiable duty to protect the public once that animal's dangerous nature becomes a known fact.
It is a perfect, enduring example of how legal rights come with corresponding societal responsibilities. You can keep the dangerous dog, but by doing so, you essentially act as the insurer of the public against it.
Right. It's a heavy burden. But before we go, I want to leave you, the listener, with a final provocative thought to mull over.
Okay, what is it?
It's something we haven't explicitly discussed yet, which I like to call the paradox of the sign.
Oh, I like the sound of that.
Think about this deeply. If putting up a beware of dog sign can be used in court by a plaintiff as rock-solid evidence that you knew your dog was dangerous, thereby establishing scienter and strict liability.
Right.
Does trying to responsibly deter burglars with a sign actually increase your legal liability?
That is a phenomenal catch-22.
Exactly. Imagine you have a perfectly sweet golden retriever. It has never bitten anyone. But you buy a cheap beware of dog sign from the local hardware store and slap it on your fence just to scare off potential package thieves.
This is for security.
Right. You were trying to be safe. But then one day, your sweet dog gets startled by a loud noise and accidentally nips a lawful delivery driver out of sheer fear.
Okay, the one worry.
But wait. Because you hung that sign, a clever plaintiff's attorney is going to argue that the sign proves you knew the dog was vicious.
They'll point right to the fence.
They will use your own security measure to establish scienter, stripping away your first bite defense and making you strictly liable. Does trying to be safe and responsible actually make you legally vulnerable?
It is a brilliant question, and it really forces you to think critically about the unintended consequences of everyday actions under the microscopic lens of the law.
It really does.
A sign meant as a harmless bluff can instantly become a binding admission of liability in a courtroom.
It certainly changes how you look at every fence in your neighborhood. Thank you so much for joining us for this deep dive.
It's been a great discussion.
We hope this highly structured breakdown has clarified the fascinating, century-old nuances of strict liability and the doctrine of scienter for you. Until next time, keep analyzing the facts, keep looking for the deeper rules beneath the surface, and always keep questioning the world around you.